What you say is the intimidation is reflected in the transcript. Ms. Love's motivation for doing it, if she in fact tried to do that, is not the relevant issue.
Mr. Copeland testified hardly at all on the 7th of June 2024, but then did testify the 10th, 11th, and then the 12th is what you referred to.
Okay, Ro.
And I understand we'll take up that motion tomorrow, but there was a lot of exculpatory information. I'm not going to agree to strike all that testimony.
Exculpatory.
Okay, well, what I mean that we'll get to tomorrow is how to, and I'd love for y'all to get together on whether there are any parts of his testimony that occurred before, the testimony that occurred before can stay.
Okay, I misunderstood.
The testimony that occurred after the motion was filed, if there are parts of that testimony that y'all can agree to, then
oh, good luck with that.
Will be great because it'll save us time and we'll have better contours about what we're dealing with. So I want y'all to get together about that and we'll think about that probably tomorrow, maybe the next day. I don't know, but not today.
Yeah, and that's a good point. Although Lil Woody's testimony was fun, we got a lot of clips out of it. We got a lot of viral content. Did he really say anything of substance? No. So I get what Brian's saying. He said the testimony was exculpatory. Got to look that word up. But at the same time, that's not really the issue. His testimony, he said, huh? No, what you mean? I can't hear. Ooh, back up. She fired. Other than that, what do we have? The issue is the jury. What did the jury hear from the state? And Lil Woody saying, huh? What you mean? And then the defense didn't get a chance to cross-examine. That's the bigger issue than actually keeping Lil Woody's testimony, is how are you going to get the jury to unhear what they already heard?
Okay, but y'all after court today can think about that together with each other. Okay.
The reason I stood
and the
up,
alkaline.
Yes.
I just want to make that introduction. The reason I stood up is the following. The state elicited testimony. Now, Mr. Copeland denied it, and they've done it with many witnesses before the Honorable Court took over the case. You've never had to testify in front of Mr. Williams, Mr. Huey, Mr. Kendrick, et al.
Right.
And you're intimidated, and that's why you're not testifying.
Mm-hmm.
I would need to show the jury that it's the state, and I have evidence now, and the judge that has been the person to intimidate a witness. So that's another issue when you're resolving this. Can the Judge Glanville, I heard what you said, but can Judge Glanville be a witness? Can the two lawyers representing the state of Georgia be witnesses? I need that in the case.
Okay, let me ask you this though. Why can't you use the transcript to get that point across? I mean, it's right there in the transcript. What it is that you assert to be intimidation.
Oh, Judge Whitaker, cuz we need to hear it from him.
Intending to cross-examine or examine lawyer Hylton and lawyer Love.
I know you're intending to, but what I'm asking you, and I don't mean to interrupt you, but I want you to answer the question that I asked you, which is why can't you use the transcript to do that?
Because Mr. Copeland can't discuss. Why are you asking these other witnesses this? And what other witnesses, how'd you treat other witnesses? There's another witness named Miss Bennett who said basically the same thing. She was intimidated by the state.
Get with it, Judge Whitaker. Come on.
I can't ask Mr. Copeland.
But the issue, as I understand what you're saying to me, is that you want to get before the jury that the state and the court intimidated Mr. Copeland into testifying, essentially. What you say is the intimidation is reflected in the transcript. Ms. Love's motivation for doing it, if she in fact tried to do that, is not the relevant issue.
But I have evidence of other witnesses who were treated not similarly, because I don't have any other evidence that there was some meeting.
Okay, let me help Judge Whitaker out. Basically what he's saying is he can't ask Lil Woody what somebody else said. He can't say, Lil Woody, why did Judge Glanville say we need you to testify? Lil Woody, why did Miss Hylton say that you wouldn't be prosecuted or that you could lie? Lil Woody's gonna say, huh? What? He can't ask them that. I'm a little confused why Judge Whitaker is confused on this. He needs to hear it from them to have a proper cross-examination, unless he's just allowed to have Lil Woody say why he thinks somebody else said what they said. It doesn't make any sense. It doesn't make any sense.
The judge and the prosecutors, like there was in this, but that the prosecutors are doing the same thing with other witnesses.
Okay.
They are intimidating other witnesses,
All right.
and Mr. Copeland can't answer those questions.
Okay, but that you can argue because you will have, look, we see that it happened here. We've already heard that it happened from the mouth of XYZ witness. Imagine it's every witness. I mean, that's the topic of argument. So I think that I'm going to look at all of it again, but I don't think that's a persuasive argument for why they need to.
Oh, come on, Judge Whitaker.
I think the transcript is what you need and what you have, but we'll take that up later, and I will think about that.
All right, so the state is up 3-1-1 right
May I
now.
just briefly address something you said earlier?
Sure.
Well, I did argue with the court that everything after the afternoon of June the 12th is void and needs to be thrown out.
Right.
I do not, just for purposes of the record, I do not concede that this trial can continue.
I
that
understand.
Okay, I just want to make sure.
A couple of motions from
Just
here.
want to make sure
so-
that's there, because you're asking us to meet tonight to go over what could possibly remain.
Well,
and I don't know that that's possible. Thank you, Your Honor.
Well, it's possible. I mean, unless I rule today that y'all have a mistrial that is with prejudice, it is certainly possible for y'all to meet tonight.
No. Absolutely. I understand that. We'll follow whatever order
right.
that you give, Your Honor.
All right, thank you. Okay, so the next motion is
We haven't gotten to the
Mr.
bond hearing
Nichols'
yet.
motion for
We'll get there.
mistrial and objection to mid-trial substitution of trial judge.
It's the
And
big
it
dog,
is
Mr. Harvey.
Quite lengthy and detailed with many subparts.
Well,
Mr.
Judge,
Harvey, are there things other than what is in the written motion that you want to
Well, there
talk
is.
about?
They're calling him
You
YSL
wanna come up
ponytail.
here, or it's fine if you stay there and hold the mic. That's fine.
Well, what I want to say is I think our motion was in seriatim. Number one, we joined the motion for mistrial.
Mr. Kendricks.
Yes. So
Okay.
I think that needs to be addressed first.
That's right,
And then
Unagi.
our motion was in the alternative. If you do not grant that motion, then we have a separate motion, which most of these defendants have opted out of.
Okay.
So I think that would be the
Okay.
appropriate.
Fine
We're
with
gonna-
me. I kind of had a note that a lot of those two motions go together and kind of have to be considered together anyway.
Well, one, I joined theirs, they didn't join
Okay.
mine. So it's a
right.
second step.
That's fine. All
Interesting.
right, so it's fine with me. We'll take up Mr. Kendrick's motion for mistrial first.
All right, we got to hear from Mr.
And
Weinstein.
his motion asserts his motion joined by everybody else except for Mr. Stillwell. Is that right?
No, I joined.
You did join this one. Mr. Kendrick's motion
If we're speaking about Mr. Kendrick's motion,
for mistrial filed July 23rd.
so I am, may I make my stance clear?
Yes.
All right, Judge Whitaker, we need a comfort break. Where's Glanville at? Send her a text, Glanville. We need a comfort break real quick.
Our stance, Mr. Stillwell's stance, is that this trial is completely broken. It's broken.
Facts.
There's error in this trial that would never survive appellate review.
There's coercion.
Illegal ex parte hearings have occurred.
Witness
Our
tampering.
clients' rights have been repeatedly violated. The
Witness
defense
intimidation.
has been mistreated in front of the jury by
Slander.
a partial judge. It's broken.
bias.
we are also winning this case. We are put in an impossible position right now because our rights have been violated, but we do not wish to move for a mistrial. We are merely pointing out that this case is broken, and I filed a motion about that, and I will get into the reasons when it's my turn. But I am trying to be very careful to make it clear that I am not moving for a mistrial, but I have extreme doubts about the ability for this case to continue, and I am absolutely certain that my client's rights have been violated throughout this process. Of course, Your Honor, I'm just going to put on the record, this is your first day here, so I'm not insinuating anything about your performance here today.
All right.
Thank you.
Oh, look at him showing love.
And, you know, it may or may not survive appellate review if it continues and if there is a conviction. That's not for me to say. Okay, so.
Dang, she said it might
Mr.
not survive appellate review.
Kendrick's motion for mistrial, joined by everybody other than Mr. Stillwell, essentially asks for a mistrial with prejudice because the assertion is that this mistrial goaded the defense into it, and under those circumstances, if a mistrial is granted, and those are the actual facts, that
Yeah, we remember he said he didn't want to do it
without the ability.
So if y'all remember in the motion that we heard from Mr. Weinstein and Yak Gotti, he basically was saying this is why we have to do a mistrial. We don't want to do it. We don't want to push for a mistrial, but we were forced to or goaded by the state into a mistrial. So that's where we're at right now.
For a mistrial based on the
Let's
state
rewind a little bit more.
Already in their response. Also, sort of in this motion and asserted in a lot of the defense motions are what Mr. Kendrick's attorney's word, the defense into making a motion for mistrial because the state thinks they're losing the case and wants to be able to do whatever with. I got the concept right?
Yes, Your Honor.
Okay. All right. So this is also a lengthy and well-briefed, well-written motion. I will hear what you want to add.
Thank you, Your Honor. I have nothing to add to that motion.
Okay.
As a lawyer, I feel compelled to speak to it, but I will sit down.
Okay.